Hello, my name is Erika Douglas. I'm a professor of law at Temple University in Philadelphia. And this video explains insights from my recent article titled Data Privacy as a Pro-Competitive Justification. Antitrust law, which is the law of competition, and data privacy law have become two of the most powerful forces in the digital economy. Yet we tend to talk about them separately. This article is really about a new way in which antitrust and privacy law are interacting. It argues that privacy protection is cognizable as a justification in antitrust law when, and only when, the effect of that protection is also to improve competition. What does that mean? This video will explain the article in three parts. First, I'll provide some background on why antitrust and data privacy law are colliding more than ever before, and why that matters to the digital economy in law and policy. Second, I'll discuss a high-profile case called Epic versus Apple. The case poses a new and pressing question that's answered in the paper. In antitrust law, can privacy protection justify a defendant's conduct? And third, I'll answer that question in two parts by explaining the arguments in the paper. To understand this work, it's helpful to first understand background on why competition and privacy are interacting. The reason why we see this new interaction is the nature of data that fuels digital competition. Digital companies often use our personal data to generate online services and to earn revenue through advertising. Think of popular online services you might use. It's our search inquiries, our social media posts, and our online browsing habits that provide the raw material for many of the digital services that we consume. Our data is used to attract advertising, which supports these digital services. Over the past 25 years, data privacy law has become a formidable force in limiting how personal data can be collected, used, and sold. But the same personal data also fuels competition between these digital services. Companies compete with each other to gather more or better data and to use it in innovative ways to deliver new and improved online services. While antitrust law seeks to encourage competition, in the new digital world, data flows often drive that competition that antitrust seeks. Because that same data is often personal, data privacy law may limit those data flows. And the result is what you see on the slide here. Data privacy is interacting more than ever before with antitrust law. This paper looks at a specific new interaction that's occurring and an interaction that's being litigated in a high-profile case called Epic Games versus Apple. The case involves a claim by Epic, an app developer and video game company, against Apple, which is the mobile device company and software company. And it's taking place in the Northern District of California. Epic was distributing its popular Fortnite app through the Apple online app store. But Apple terminated Epic's access to the store when it failed to follow the store rules. Epic then claimed that Apple had violated Sections 1 and 2 of the Sherman Act, which is a major federal antitrust law, as well as state unfair competition law. And Epic argued that this violation was because Apple had imposed these App Store rules that restrict payment and distribution options for applications. The district court judge in this case, Judge Yvonne Gonzalez-Rogers, applied an analytical standard called the rule of reason. It proceeds in multiple burden-shifting steps. First, she found that Epic had actually carried its initial burden, often a difficult task for antitrust plaintiffs, but Epic showed that Apple's App Store rules had prima facie anti-competitive effects. But at the next step in the analysis, Judge Gonzalez-Rogers found that Apple had established justifications for its conduct. The conclusions on the justifications are not particularly clear, but there seem to be two, both related to privacy and security. First, Apple's rules for its App Store were accepted as justified because those rules improved data privacy and security in the App Store for end users like you and I. The rules enabled human review by Apple and the removal of insecure apps, such that if we were to go to the App Store, we might expect that the apps we download would be private and secure. And then, relatedly, there seems to be a second justification that this improvement in data privacy would enable Apple to better compete with other mobile operating systems, such as Android. The case is important here because of this second step, where the judge accepted Apple's argument that data privacy and security could justify its conduct. This was one of the first US cases to accept such an argument. And the result was that Apple avoided federal antitrust liability in part because of these privacy-based justifications. And that was despite that initial finding that Apple's rules appeared to be anti-competitive. The Epic versus Apple case was pending on appeal before the Ninth Circuit when this video was recorded. But the question's not exclusive to Apple. The same argument is being repeated by many digital platforms. Giants in social media, online search, and mobile application stores are making similar claims. And the claim is often that online competition must be sacrificed in order to protect users' data privacy. This article looks specifically at that second step in the Epic versus Apple analysis and the rule of reason. That point at which a defendant has to justify its conduct in order to avoid liability. And the article analyzes when data privacy is and is not such a justification, which Apple versus Epic only got partly correct. The article explains the answer to this question in two parts: when data privacy protection is cognizable as a justification, and when it is not such a justification. Let's start with that first part. The law on this issue has not been expressly decided, but as the article explains, there is more general US law on what constitutes a pro-competitive justification. For example, the leading case of United States versus Microsoft, which is from the DC Circuit, describes a pro-competitive justification this way. It's a non-pretextual claim that the defendant's conduct is indeed a form of competition on the merits because it involves, for example, greater efficiency or enhanced consumer appeal. Now, despite this variation in how justifications are described by the courts, many courts tend to share this focus of Microsoft on improved competition, enhanced efficiency, and increased consumer welfare. And so in the jurisprudence, the ultimate question is often one of pro-competitive effects. If the conduct is shown by the defendant to have such pro-competitive effects, then the defendant will often be able to establish a justification. In the article, I apply this law to the recent claims of privacy protection as a justification. I contend that privacy protections could constitute a justification in antitrust law where their effect is pro-competitive. I argue that existing US law permits recognition of new types of justifications. They have evolved over time. So there's nothing that in that law that would preclude privacy from being recognized as a justification if the required condition of improving competition is met. I also draw on international law, which has recognized privacy protection could constitute a justification. And here I use a Canadian case called Commissioner of Competition versus Toronto Real Estate Board. Canadian competition on justifications is similar in relevant respects to that of the US, and this case recognizes that privacy could constitute a justification. So existing law applied to privacy protection as justification arguments could allow them to be cognizable, provided that there are pro-competitive effects in the relevant market. That, of course, leads to another question that's answered in the paper. When might privacy protections actually have these types of pro-competitive effects? When showing a justification, defendants will often use economic evidence to demonstrate that a restraint or conduct improves economic efficiency and so has a positive effect on competition. And we can see this in Supreme Court cases like Continental TV versus GTE Sylvania, or Legion Creative Leather Products versus PSKS. So drawing on the economic literature, I apply the law and consider the economics to develop two scenarios in the paper where privacy protections could constitute a justification because their effect is to improve efficiency. The first such scenario envisions privacy disclosure rules that help to reduce information asymmetry between consumers and businesses. Privacy economic literature finds that consumers are often severely hindered in their ability to make decisions about their privacy because they have little information about how their personal data will be used relative to the companies who use it. So I use the example of an app association that requires its members to make privacy disclosures. Such disclosures could reduce the data gathering that fuels advertising competition, but they can also ultimately improve competition between apps to offer privacy features as consumers become more aware of when they're being tracked in apps, for example, and so make different choices that in turn fuel competition. The paper also examines a second scenario where data privacy restraints could limit same brand free riding and enhance competition between different brands. In the interest of time, I'll leave it to you to read those sections, which include a critique of the Epic versus Apple case. Finally, the paper answers the other half of that initial research question. When is data privacy protection not a justification for anti-competitive conduct? The Supreme Court has found that restraints on competition cannot be justified by a defendant simply because the effect of those restraints might be to improve public health, safety, or other societal interests that are unrelated to competition. This is clear law. It's established in Supreme Court cases like National Society of Professional Engineers, Indiana Federation of Dentists, and more recently, NCAA versus Alston. The defendants in these cases tried to argue that the limits that they placed on competition were justified because of broader benefits to the public that didn't relate to competition, such as safer buildings in National Society of Professional Engineers, better dental care in Indiana Federation of Dentists, or support for higher education in NCAA versus Alston. The Supreme Court has always rejected these arguments as, quote, nothing less than a frontal assault on the basic policy of the Sherman Act, end quote. What is that policy? As the Supreme Court explained in National Society of Engineers, the Sherman Act makes a legislative judgment that competition is positive for consumers. The arguments in the cases on these slides rely on the premise that competition could be harmful to consumers. The Supreme Court explained that even if this legislative judgment that competition is good is not correct in every situation, the statutory policy of the Sherman Act precludes inquiry into whether competition is good or bad. In other words, the judiciary is not able to sacrifice competition to indirectly protect the public against other harms like health or safety through the Sherman Act. Therefore, when considering if a restraint is unlawful, the court's inquiry under the Sherman Act is properly confined to competitive considerations. And that really brings us back to the thesis of my article. For data privacy to constitute a justification, that protection must also improve competition. That means if a defendant simply argues that protecting privacy is generally good for the public, despite limiting competition, that's not cognizable as a justification in antitrust law. That's not to diminish the importance of data privacy protection. Much like the protection of public health or safety, which was invoked as an earlier potential justification, there's no question that the protection of data privacy is a deeply worthwhile sociopolitical goal. I agree that privacy protection has public benefits. The problem with this defendant's argument here is that it's untethered from competition. And that connection to competition is essential for recognition as a justification in antitrust law. So this argument is really just indicating the bounds of antitrust doctrine when it comes to data privacy. This highlights an important and unresolved policy question, which I'll leave you with today. Given these bounds of antitrust doctrine, we can imagine a defendant who's left claiming an important and legitimate need to protect the data privacy of its users, but where that claim is unrelated to competition, it's not recognized by antitrust law. In that situation, this article and cases like Epic versus Apple point to a broader policy question about trade-offs. When should the law prioritize privacy over competition, or vice versa? The lessening of competition, where it promotes other socially beneficial conduct, be it health, safety, privacy, is beyond the bounds of antitrust alone to decide. But such trade-offs are a pressing and legitimate issue for consideration by policymakers more broadly, particularly in the digital economy. For more on this and other new ways about thinking about privacy and competition, I invite you to read my broader research, which is available at the SSRN link on this slide. Thanks so much for your attention.